Hello, good evening everyone. Welcome to the Losico YouTube class. Today we have with us Shashwat Kapat and he is being working currently with the DIFX Digital Financial Exchange Dubai in UAE as a legal concern. Today in our Losico YouTube class, he will be giving a lecture on choosing a Web3 fundraising document in 2023, a playbook for funders, and how to draft a SAFT agreement. Today, further, everyone is requested to mention the decorum of the session and keep the environment friendly. Now, sir, you can start.
Yeah, thank you, Saloni. So last week we went through the Web3 fundraising process and how exactly it happened. Is it a little bit different from normal Web2 companies or means the startups fundraising process, or how to exactly draft or what is exactly the specific modules for that? What's the instrument to raise the funds there, and what's not to do, what's to do? But to sum it up, why we needed to discuss separately for supposedly crypto companies, for blockchain or Web3 in a separate circumstances. Why we couldn't do the like same process, regulations, same applications, same legal agreements, documents for Web3 and Web2 all. Because the thing in these scenarios from after 2027, when exactly the Bitcoin and whole of this ecosystem started, this both side of spectrum got little bit more diverse in a different manner. So to start, we need to go back into 2007, 2008 in USA. After 2007 in USA have a bigger recessions. We have hit with an economical crisis, and in USA, you know that that is called in economic suppressions and depression time has happened. And what has caused out of it? Lot of big US international banks, multi-billion dollars of those banks got evaporated suddenly, and the mortgage bonds in USA and lot of different debts accumulated in USA, and those home loans and those different debt ratios has created a severe pressure on USA economy. And because of all that, economy has failed in USA. Banks failed. Lot of bigger brokers, lot of biggest capital companies has got down. People got jobless. People didn't had enough liquidity in their accounts to do any financial activities. And when USA is the biggest economy, that effect has gotten into Spain, Greece, and European communities and companies, and overall the European Union. And that got affected in India, China, a lot of Asian companies, Asian countries, and overall the globe. Why is this context is necessary to understand from what belief and thoughts this parallel financial economy, this Web3 economy, or you can say crypto, all this sort of emerge. What happened? The power of economy was very much centralized, and it was deep rooted by few of the controlling banks, the not the banks you actually think of in our purview. There is this SBI, and then there is this private bank, some of the government banks, and these banks, and some of the international bank like HSBC, Deutsche Bank, and those banks. But actually, the bigger of the bigger fishes in this pond, in the Goldman Sachs, Morgan Stanley, and the biggest asset managers, BlackRock, Vanguard, Fidelity. These are the groups of asset manager who actually controls the economy in a global scales. For in statistics, whole world's economy if constituted under $90 trillion, this few of these asset manager actually control 60% of whole global's economy. And if you control this much of $1 trillion, then you have a say. So supposedly, any of the biggest bank or capital companies, or maybe in a self asset management company fails, whole economy has a slippery slope effect. Everybody get affected severely. From that belief, or we can say according to that philosophy, there is a lot of point of failures and lot of economical intermediaries between a person to person's direct financial transactions. So when 2008 Bitcoin came, it was first peer-to-peer, permissionless financial transactions enabler. Means you can directly send someone an financial contract for their financial uh, gains or supposedly there you can complete one transactions without involving any intermediary. Before that, that was not possible. So at the first, governments, regulators, banks, they didn't think that much of it because it was a small scale. Like for an example, first Bitcoin was sold, it was like 10,000 Bitcoins were sold for one pizza. So there's a no value or nothing. It's a like a experiment. People are just trying out new technologies. Very few people, some of the techies in the USA and Western parts, they just started using it for normal fun stuff. But gradually it became serious. Gradually, lot of evolutions regarding these distributed ledger technologies, this blockchain, crypto, all started happening in 2012, 14, 15, 16. And people started pouring their fiat money, means the banknotes and their own government issued or government central bank backed currencies into this crypto. So the from conventional financial economy, the money get transferred into crypto, and gradually the billion and at the point there's a trillion of dollars started to be in the part of crypto world. And then government, banks or regulator started taking notice of it. And they thought first they are losing their powers, their control, their authoritarianship, and some sort of a their capabilities to control the flow of uh, their government, control of the lives of the people, control of the financial stability also. It's not only one side of light and the government and regulators and banks were the villains, not at all. Some of the crypto stakeholders, some of these biggest Web3 companies, they think like that, hey, we are the Robin Hood of the this whole economy system, and we, the governments and regulators, are the bad persons in India. Not at all like that. If you consider in the Indian context, in India, it's an evolving economy, but supposedly there is in India still literacy rate is very lower in compared to the general consensus to be reached to understand this core deep tech technology. And it's expected that most of the people will not understand that. General people. Still it's not been giving them the knowledge. So when the normal people, supposedly a farmer, supposedly a shopkeeper, or whatever, maybe they don't have that. Supposedly, these people's one few of them doesn't have that enough knowledge to use those technologies, and they started using it, and they make it more like a gamble because you need to know a lot of different things about this world to actually use it. And it's a very volatile market. That is that cannot be like you can not say that it's not like that. So when these kind of things happen, people might lose a lot of their money, a lot of hackings can happen, and obviously the biggest issue is money laundering. So lot of the black money gets wiped through this crypto. Lot of the crypto terror financing has been done through crypto. For an context, Russia-Ukraine's wars, both sides' biggest aid funds has gotten through crypto. And recently, the Israel and Palestine wars has been deeply have a part in crypto. Supposedly, the Hamas, they're for a long time they started accepting Bitcoin and crypto as their donation manner. And people all over the world, whoever it is, we will not go into the political side of it, but they started giving them donation on a Bitcoin. But later on, what happened? They stopped accepting it. In the word, they completely stopped accepting it. That Israeli police track the Bitcoin through their ledger system, that where exactly fund is getting into. So they could track Hamas location through that donation. And lot of also these crypto companies and lot of the different bigger government and politicians or industrialists supported also Israel this war through crypto payment and all that sort of donation mechanism. So those are also have a very big side of a financing different war and all that sort of things. So governments and regulators doesn't want to get permission of this kind of technologies or this kind of financial power to somebody without any regulated guideline. And there's the thing, every government, every regulator think any of this new technology in a different way. Some are pro-innovative, like supposedly in this UAE government, means United Arab Emirates, Dubai is a very pro-innovation regulations. So they have set up their own regulations. We call it the Virtual Asset Regulatory Authority, VARA. And in Abu Dhabi, there is ADGM, Abu Dhabi Global Market. And they have created regulations for virtual assets, I mean, crypto, NFTs, smart contracts, blockchain, metaverse, a lot of the different innovative technologies. And they wanted to regulate it without banning it. And they started to do it by very strange regulation, but they made it sure that regulation is in place and you can do it if you've complied those regulations. Some countries thought that we have a age-old securities regulation, like supposedly in USA, their Security Exchange Commissions means their counterpart of our SEBI. They thought that okay, we have a 1934 Securities Act, and through which we can regulate the crypto securities and all that. And there is also one challenge when you want to regulate a new age, a new technology with an 100 years old regulation which was not up to the mark for today's time, then you will might be facing a lot of challenges from the both the sides. Then some country took an wait and see approach, like supposedly India. They didn't react at the first, but when the industries have grown at a very large capacity in India also, then they put a onerous extreme taxation regime because they still think it's a very risky market, and they treated it same like a like taxation of a gambling, like 30% flat tax into pay 1% TDS and all that sort of thing. Usage in India in crypto has gone down because of that. But now we are hearing after the G20 summit in India that India is actually writing the drafts of the crypto regulation in India. Probably by 5 to 6 months, they will publish that draft. And some other countries like the European Union, how they have regulated data protection, data privacy in 2017 through GDPR, a comprehensive regulation which has been followed and which inspired a lot of other countries to create their own data protection framework. And it's become a standard, like you can say, setter in this data protection regime. In that way, European Union, the 28 member countries have uh, created this MICA, the and that is their comprehensive crypto regulations. But yes, they doesn't regulate NFT still now. Probably at MiCA 2.0 they will bring that, but at least the cryptos has been regulated by them, and they have created the timeline by 2024 to 2025. Probably they will be completely enforced. So it's a long introduction, but what I tried to say in the first, if you are a lawyer wanting to service your clients in this field, or if you're a law student who is still learning about this new emerging financial economy, or you are a founder, or you are any part of the stakeholder in this whole ecosystem, you should need to know you need regulation to thrive, because without the government and regulator and bank selves will not be able to survive here for a long time period on a good side of a law. And also, if you are the other part, if you're the government or like service, or you are from a regulator, then you also think that there should be a balance. So this balance between this innovation and com- comprehension and innovations and you can say little bit of a risk-based approach, there should be a fair assessment. But unfortunately, most of the countries still didn't or had not been figured out this thing. And so what happening? Lot of these Web3 companies and lot of these uh, projects who are working in this space, they're struggling to find their perfect legal entity, because if you supposedly tomorrow made an in our world the private limited company in India or in other country like USA, LLC, limited liability company, you might be getting attacked in a very legal prejudice manner. Or supposedly you are enabling every crypto transaction on your platform, then maybe you are giving permissions to money launderer to launder money through your platform or do the terror financing, and then government will come against you, or maybe you do not like to do that activity to accept some money laundering activities in your platform, and maybe some other persons will steal your intellectual property, they will infringe your rights, and that there is no might solutions enough perfect solution for this field. So for my personal experience, whenever a new startup founders or supposedly a Web3 company comes me as a client and they ask, right, how can I protect my companies and how can I protect rights and how can do it a very legal way? Is there a perfect solution for it? Unfortunately, mostly I have to give a answer. It depends. And second point is might not be there is a perfect solution. So supposedly in India, if you want to create a crypto and Web3 company, there is not a perfect solutions we can provide. There will be always stopgap things, which is can be just make it work. Not is a very simple, straightforward process. So if you are building in this space, you need to be remember the laws are yet to be in place for most of the situations and for most of the countries, and if you're still willing to take the bet, you should be prepared to take some side of a compromise from both sides. So the biggest thing in this whole ecosystem, what I call, you need a legal wrapper. What is this legal wrapper? Means a legal safeguard mechanism to make your company doesn't violate any law, or make sure that any country government or regulator should not catch you on failing to do any kind of legal structure. So before starting a company, or already you started the company but you are taking or you're raising funds or you have some sort of a window of a cash, then your first bet should be choosing where country you should be incorporating, where country should your legal structure should follow. So there is also answer is very much depends upon the operations of the budget of you. Supposedly for an example, um uh if you think to create your startup from Delaware LLCs. Mostly, most of the startups in you has tried to do through this USA startup friendly jurisdiction. Challenges might be the USA security commissions, the SEC might come find you and maybe question you on a legal violation, which you might not knowingly had done that, and your company may be completely gone out of business. So maybe US is not best suited for you. Then you might be looking to start your company in Singapore because that is also one of the very preferred location for the startups. But and also the Singapore is a very crypto and Web3 friendly company. The government and Singapore has this monetary authority of Singapore. They are regulated and they have different regulations for this. This they call this payment regulation. There is called this they are called DPT. They have says that digital payment tokens, and they categorize crypto and NFTs under DPTs, not NFTs completely, some sort of NFTs, because mostly the NFTs are fungible in nature, and digital payment tokens doesn't categorically accept that. Let it aside, they have a comprehensive regulations, but practically, when you think for a theoretical point of view, it's a possible to start your company in Singapore. But if you have a very limited cash and your startup doesn't have that much of a fund to be cash out, getting a license in crypto companies in Singapore is very, very hard in a financial point of view. It's firstly very much cost exclusive. It will take a lot of cost. It's expensive and it takes hell lot of a time. It may be 1 year, 2 year, and till the time you don't have any license. And another jurisdiction is mostly lot of companies are right now taking in, that is in Dubai, because Dubai has a lot of these free zones. You create a free zone entity, and after that you go to this VARA, Virtual Asset Regulatory Authority, and take any license, exchange license, custody license, broker dealer license, advisor license, payment settlements license. A lot of different licenses are available, and you take it and you start doing. But I personally help few of the companies to get their VARA licenses, and it's firstly also expensive. Second point is it's requires lot of policies, compliance, lot of internal regulations, guidelines, and lot of legal stuff you need to be get sorted. Like it's more of a like a when you try to get an RBI fintech license, or moreover you try to get into yourself into SEBIs. So there you need to lot of legal compliances. Same in VAR. But that is minimum you have to do to start any companies and get a license in any jurisdictions. But what happened, lot of the smaller of the startups has found a nest in two kind of jurisdiction. One is European jurisdiction, another one this offshore jurisdictions. So first into European, as this MICA regulation in Europe just recently has came into life, not it long before it was a common practice. There is few of these smaller European countries who found this opportunity that a lot of the bigger economies are not regulating crypto, or they do not giving a good advantage point of view to choose them as a jurisdiction. So this country has a very lower tax regime, which is always a boon for the startups. And secondly, they have created a crypto or virtual asset service provider law. We call it VASP Acts and regulations, and they give some sort of a regulatory licenses from this from their country's regulator. And when you are regulated in those jurisdictions, you can at least show other countries that hey, I am regulated, I am working under legal oversight of this regulator, and I am in the positive side of law, and I can do business. A lot of companies started doing that. So these jurisdictions are Estonia, these jurisdictions are Poland, Romania, Croatia, then some sort of a not a regulation but supportive nature, Turkey, then little bit that we can see in the Liechtenstein. This is a very short, small jurisdiction country. Most people doesn't know about it, but they have comprehensive regulation. And one of the few biggest country in a financial proposition has done it. It's Switzerland. 2016-18. the biggest of the protocol layer, this L1 Ethereum. Their Ethereum trust is incorporated into Switzerland, and Switzerland had a lot of different tokenization regulation, crypto regulation, virtual as a service provider regulations, DLT regulations. They were very comprehensive regulations. But the problem is, as we know, Switzerland is a very expensive country to live, and likewise, the licensing and incorporation in Switzerland is a very expensive process. But this is an option. But most of the other companies thought that maybe we don't want to get into Europe at all for a licensing point of view, because for a time being, they're called governments or the countries known as offshore governments, the offshore countries. These offshore countries are some sort of in Africa, America, South America, and Asia's jurisdiction, where they are these island jurisdictions where their more of their income or their GDP comes through either tourism or either giving the outside companies a nest for their home. Means biggest of biggest companies, if you can think of, like Google, Amazon, and some of the biggest billion-dollar companies, corporate entities are located into these offshore countries for first tax benefit, and second, they give a regulatory little bit easier oversight, a regulation which is more suited for this kind of companies. And they also found a pattern that at this point of the time, we should take this plunge and we should try to regulate this crypto, metaverse, NFTs, and try to create a regulation so more startups, more Web3 companies will come at our place and they have implemented that, and obviously that thing can happen. So lot of different companies started coming into start their IBC, we call international business companies in those jurisdiction, pay zero tax. Actually, corporate tax in that those jurisdiction mostly as zero, and they don't need a physical office there. They can create a virtual office. So most of the founders never visit their this offshore companies, and they will just hire an agent there to take over it as like a local director. Mostly the law firms or the lawyers who have done the incorporation or licensing process at that jurisdiction, they take over this role on a fixed cost, and you're good to go. You have license, you have entity, you don't pay tax, and you can do business. So those jurisdictions are mostly the most preferred and the top level jurisdiction in this offshore world of licensing in Web3 are Cayman Island. Then there is BVI, British Virgin Island. Then you have Panama, Gibraltar, Bahamas, Bermuda, Marshall Island, St. Vincent's Gate. You have St. Lucia, St. Kitts. You have from here Mauritius, Seychelles. Then you also have, I think, from Malaysia, there is one Islamic free zone uh, offshore jurisdiction called Labuan, Cyprus. These are the few of the jurisdictions which just came into my mind I could talk about, but there's a lot of these different jurisdictions and people just start. So a lot of this token offering company, what we call this SPV, last day I talked about it in the last week session. This special purpose vehicle, this initial token offering company, they mostly start into this Caymans and BVI, and one time purpose, one time cost, and you get out and you do a token launch that is regulated under there. Then again, most of the time they create a corporate structure there. So supposedly one company start their foundation ownerless company in Cayman Island. They create their treasury entity in BVI to hold their assets in their custody. Then they do token launch in Gibraltar, and they attach their IPs in supposedly Seychelles or Mauritius. So these whole offshore structures that is been done by their lawyers to structure their companies at somehow there's a taxes minimum, Government regulation, government point of view and regulatory point of view, they are in a green light and they pay less and they create a comprehensive legal structure which can be workable in their fashions. Now, in that context, a lot of the Web3 companies start to do DAOs, means decentralized autonomous organization. For the concept, DAOs should not be regulated, right? It because the thing is, it's a more about decentralized organizations. There should not be any corporate structure. Members vote through their governance tokens, and people get benefit out of it and take a consensus decisions to make amend of their proposals and do any activities. But if these DAOs do not have any legal identity, first problem many people face. Supposedly, DAO hire an employee, right? They can do that. And they don't pay that person after making him work. What's the legal recourse for that person? Or maybe a DAO has a treasury of 5 million tokens. Somebody got the access into DAO, hacked into the smart contract, and taken out all the assets. What legal recourse this DAO will have? Supposedly, in DAO, one member somehow through this digital format or maybe in chat or somehow sexually or somehow do an assault on somebody. What's the legal recourse there? Or supposedly, these DAOs are creating a financial model. And whenever there's a finance involved and there is a revenue generated, revenue ecosystems generating, and capital generated, who will hold the accountability if anything goes wrong? Who will make sure the investors get not duped? Then they need a legal representations in from a legal point of view. So what happened in USA? There is one DAO called Oki DAO, and they are not incorporated, right? But there is a few promoters who actually started the DAO, and some people joined them, and eventually it became a bigger DAO. What happened? The Commodities Future Trading Corporation, the CFTC in USA, there's a commodities regulator. They sued this Oki DAO in USA court, and they said that these persons were running this kind of commodities trading futures business, and they are not regulated, and they are doing it by regulatory violations because there is already a regulation and licensing for them. What happened in the court judgment? Court ruled as this DAO was not incorporated, so they would assume this DAO is a general partnership. Means every each member of the DAO, every each token holder of that DAO will be assumed and presumed as the DAO members, as the partners of an general partnership. And whenever in a general partnership will be assumed as a partner, then your liability will be maximum, unlimited liability in the legal term we call it. Means if anything goes wrong, you hold one token of that whole DAO, you might get sued, you might get bankrupt, you might get go into jail. Anything can be possible. So this maximum liability is not no good thing for any DAO or any company. So why? How to solve it? So a lot of the DAOs go through this Cayman Islands. They have this legal structure we call it ownerless foundation structure. So this will be a foundation plus a trust where there will be no direct owners of the company because in DAO you cannot have an owner. So they will be the beneficiaries of the companies or the trustees of the companies of the DAO. Sorry. So this kind of structure is a very rampant practices, and a lot of these different legal structure are there. In Bahamas, also some sort of same regulations for DAOs are there. In Marshall Island, they have personally drafted a regulations for a DAO, and I was one of the part of this their drafting committee. So we saw that in that jurisdiction, you can create DAOs through a regulations, and there will be enough precedents and structure to follow for a DAO. Then in USA also, there is few of the jurisdictions recently, Colorado has brought forward a DAO regulations to incorporate DAOs under DAO LLC and give them some of the legal rights, legal obligations to create the better manage the situations. And the first states in USA or the whole globe itself to regulate DAOs was the Wyoming law, DAOs laws, but that was very flawed. But it was a first attempt in any kind of this kind of situations. So you need to think maybe DAO is a very appreciated form of philosophy and from a very efficient mechanism point of view in this Web3 ecosystem. But as a founder, are you actually willing to take into this deep bait to do uh, this kind of DAO setup, or it's not be best bet for you? If, because DAO mechanism and DAO setup is not a suitable mechanism for each of the type of activity in this kind of ecosystem. So you need to analyze that. You need to take a better decisions around that. You should not go into the hype train just because everyone's making DAOs or talking about DAO in Web3 ecosystem. Second, DAO tokens and security. It's not about only DAO tokens. I talked about that here, but mostly it's about any crypto as securities. So what happened? I given some of the previews about it, but most of the times in USA, in some sort of in Australia, UK, France, Germany, and Canada, lot of these jurisdictions regulators started saying, mostly in USA, they started saying that whatever the crypto it is, they are all fall under as a security. So in the corporate legal world, we know in securities all obviously will be regulated under the financial securities regulator, and they need investor protection mechanism. They need to comply very stringent laws of regulations because after all, these are all investment vehicles some way or another. So in that sort of a structure, uh, what happened? Except Bitcoin, SEC in USA have told that all other cryptos tokens are securities. So what is this blanket classification? In this blanket classification, all other cryptos will be considered as a security on the basis of in USA's age-old test. We call it the Howey test. So there will be an four prongs of how it is we call it. That is an investment of money in common enterprise with a reasonable expectation of profit and to be derived from the efforts of others. So SEC or a lot of other regulators try to classify all the cryptos. So means that there will be an investment of money. Means I myself, if supposedly I buy mm, five crypto tokens, any tokens maybe, I have done my investment of money through that because how I able to buy that exactly that crypto. There will be a common enterprise means there is very much a community of the people who thought that okay, I should invest into this crypto because the price will increase, I'll gain something, or I can use it somehow. So there is a common enterprise among the people with a reasonable expectation of profit. I did that because I expect some profit out of it and to be derived from the efforts of the others. So means I need not to do anything. I just need to invest, and the project builder or the people who first issued the tokens will actually make it very weak and will earn the money. So actually, this all reasons make sense for SEC. But if you go deep, most of the crypto projects are not about only investment. Are not that there is will be always an investment of money. Always there is a no reasonable expectation of profit. And it's not the case. The promoters will actually make the price of the tokens much larger. It's outside look like that. But if you go into deep into this ecosystem and from a legal point of view, it will not. So this is how a famous USA judgment has recently been passed. That is in Ripple versus SEC. Ripple is an crypto company. They had their token XRP tokens, and SEC has argued that this is insecurity. So the Ripple has went to this court, and the court Judge Torres was the judge who actually given this judgment, she told that, see, when the issue Ripple was went into market and Ripple's XRP token first issued to the institutional investors who actually know what's actually going on, that issuance will be considered as an investment contract. But generally, when in the retail market XRP token was sold to the users or the people bought into the project and ecosystem, they are not securities. But the judgment was very much, you can say, crucified by the anti crypto regulating persons, and all those other stakeholders say, hey, it's a win for the ecosystem. But actually, what it does entail, there is no perfect regulation at this point of the time. It's some people can argue it's like, yes, these tokens and cryptos are securities. This is the reasons because they have their own share of arguments. And obviously, the opposite share can argue that it is not the case. So that's why in USA and also other countries, the Congress or maybe there's legislative bodies or other regulators are drafting regulations to classify cryptos as in special financial assets, how to regulate them, how to avoid the bad actors in this ecosystem, crypto ecosystem or other ecosystem, to not to make the prey of the common users or retail users or the investors' money, how to create an investor protection mechanism, how to not the normal conventional markets, insider trading and insider trading regulations can make into this ecosystem. So it's a fair trade between balance of both age-old practice of securities regulations, commodities regulation, financial market ecosystems regulation, and asset regulations, and try to make a fair bet between both of them. So this I just covered. So yeah, this is a charter I just tried to show that Swiss Foundation, which I just told, like Switzerland had created the foundation regime mostly suited for Web3 companies. So Ethereum was one of the first companies to take that and incorporate under the Swiss Foundation model. And I till now talk to many lawyers and many Web3 stakeholder person. They don't know even that Ethereum is incorporated. But the thing is, you cannot avoid regulation. You cannot avoid any kind of laws. It's better to be in the right side of that spectrum, whatever is available, and make big of that. There's another one Web3 company, there's a Dash. They also created this mixed mechanism. I said this offshore trust. There is any offshore jurisdictions, they have created the trust. And they also, because they are operating in USA very heavily, they have this USA C Corp company. So I think mostly this C Corp company, whenever you find any entities, that is just to be in the USA, because without that you cannot do very much legally on a from a regulator point of view. But most of that crypto specific activities of them or OT specific activity of them have been done through this offshore trust. Then this Meta Cartel Ventures, another one, this kind of portfolio of projects in Web3. They also done through US LLCs, but as they are not into core crypto tokenization and those kind of activities, they are in like leeway, they can still do it, but they're still all facing it, all are thinking to create some sort of offshore or outside jurisdictional entity. So there is this ENS, the Ethereum name service, and API 3. A lot of these companies, they also done through this Cayman Foundation company I just told you guys. And there's this blocks, they also created the DAO. And already there is an US DAO. So there is this Wyoming, I just said the first state to regulate DAOs. They are done through this Wyoming DAO LLC. Then this Lex DAO. I'm part of this Lex DAO. They are a legal Web3 lawyer community from across the globe. But we are also US unincorporated non-profit association. Yes, why we told this much and we are unincorporated? Because first of all, we do not issue tokens, we do not do crypto. We are just associations who help into crypto policies, the legal side, and giving people advice on free of cost. It's most of a think tank kind of situation. So we do not hold any liability towards anyone, and we do not do direct crypto activity. So that's why we don't need that. But generally, this kind of situations you should do the associations. So there is DOIDX companies. They also this the Gunsry. This is another one. This African this Web3 friendly offshore jurisdiction. You can do that through there also. So what happened in 2017-18? Lot of the Web3 companies started doing the ICO. I told you last week that sorry. So there is this ICOs, this initial coin offering, initial token offering. And 2017-18, lot of these companies are done through USA and lot of these jurisdictions. So supposedly there is a one big Indian company. He's also in there in Polygon. They also done this their Matic token issuance through those jurisdictions. The problem has happened afterwards. SSC comes and they said how to do this IPOs and public issuance. You didn't do that through that mechanism because those cryptos and tokens didn't fall directly under that. Those companies didn't think about that. So come now the SEC started to saying that they're in their process, like how we do this prospectus and those issuance disclosure, a lot of these things. They have this regulation D, A, C, D, this kind of mechanism. Why did you guys didn't follow? Some companies started to follow it, and they also didn't get the enough right answers to complete the procedure. What happened? Because again the same problem, when the regulation is built for one purpose and you try to fit it for another purpose, there will be always a friction, and that cannot always go in well with those three kind of ecosystem. So yes, this kind of issues started to build, and companies and founders started to move into friendlier jurisdiction where they can have a better flexibility, better independence, and better regulation at the cost. But there is a dark side of this whole coin. What is that? That is the situation. If you know that there is one big crypto company that is known as FTX, and they have you can say have a big corporate governance issues. They have just fondled with customers assets, so and they couldn't pay back, and they went bankrupt, and the $4 billion of users fund just got lost in a week. And their founder SVF's still fighting in the court till now. His trial is going on live. You can watch it on the YouTube as well. So this kind of failure of the companies or the bad actors play, the malign actor plays in those ecosystems just to rob money, those kind of situations is also very relevant. So whenever you are fighting an illegal structure for your Web3 company, you should have a very strong compliance mechanism, means KYC. KYC is a very important thing. It's not that all only banks do. Lot of the crypto exchanges, I think not lot, all the crypto exchanges who are in centralized ecosystem, they do the KYC, mandatory compliance checks, mandatory look into risk assessment. If they are doing accessing from sanctioned country, they should not use it. So there is a lot of these compliance checks and policies and procedures that should be in place for you. So it's about not about only legal plus compliance structure should be in your place for your Web3 companies. So it's more about the concept of the sorry for the IP aspects of NFTs. In NFTs, that is one of the biggest important thing is the intellectual property, because the underlying tangible assets of that, exactly the non-fungible tokens. But unfortunately, IP rights of the NFTs are still now hit and miss. So what happened most of the times when you are issuing an NFTs or buying an NFTs, you should follow through the issuer of the NFTs or the from the marketplace, supposedly OpenSea or some other marketplaces. You are buying those NFTs, go through their terms and conditions, your rights, your royalty rights, your licensing, and all that sort of things. Those are only binding rules and regulations for you. Go through them, understand that, and if you are comfortable about it, then only pursue that because NFT is much more volatile than a normal crypto. Now, into context of a very deep end of our conversation, it's about the term I say triangle of Web3 jurisdiction. So what exactly jurisdiction you should prefer when you supposedly starting a company from India or maybe from Asia? That should be your, there is a triangle that should be your UAE, Singapore, Hong Kong. These three Asian pinnacle financial institutions. So there is this Dubai and Abu Dhabi, both equally, but mostly I prefer Dubai for the jurisdiction because they have created much more comprehensive regulations, and Singapore, Hong Kong. So for OF3 companies, most of the preferred thing is banking service, government regulator side, and have a high net individual persons and very comprehensive regulations. So you, if you regulated in this kind of jurisdiction, better chances you can also have a better practice in other parts of the globe. Means these offshore countries and the smaller European countries, whenever they give a license, as the other countries has started to know it, their standards of the regulations is a little bit on the lower side. Now compared to this VARA for Dubai, ADGM for Abu Dhabi, MAS for Singapore, SFC for Hong Kong, their standard of the regulations and their compliance requirement is much more stricter. So when you pass through these kind of strict compliance and regulations and get a license and rights to do the business from those jurisdictions, then other strong economic jurisdiction give you permission that okay, they are done enough of it, so they can pursue them. So that's why this jurisdiction were preferred, but little bit expensive as well. I think I already covered MiCA in different part. So MiCA is a more of a European conversion of a GDPR who had done for data protection. They are trying to do it same effect through in crypto when Web3. They still didn't cover some part of it, but I think gradually the MiCA 2, 3 amendments will cover it. But if you supposedly are very much serious to do your business in Europe, and also the thing is you want a global consent regulation which are very comprehensive, very comprehensive, has a banking authority, have a regulatory permit and oversight, your best bet is to go to MiCA. Right now, I'm helping 3, 4 companies to get better aligned with the MiCA's regulations. But then also you should assign one host country. Host country means in from Europe's, which of this European Union's member country you want to start your companies. Then you should start to prepare MiCA because MiCA compliance will take 1 to 1.5 year for any Web3 companies. It takes a hell lot of a time because it's a very comprehensive, very strange regulations. And from there, after you are MiCA compliant, which is probably by 2024 and 25, at except USA, because USA situation is very much a political situation right now in crypto regulations. Democrat versus Republic, not going there, but except any other jurisdiction, you might be able to do operation very freely, very openly because you are a regulated entity. So that's why I'm saying that implementing privacy measures. So in crypto, the privacy is one of the, on Web3, the privacy is one of the biggest assets. So privacy should be core part of your business. Your AML and KYC compliances, what I just told, it should be very much structure. And legal structure doesn't always mean only you're creating a legal entity and you are end of it. It's more about contractual agreements mean between the partners and all that. Because you are a Web3 company, you don't need to care about that. That's a completely false. You are still a normal structure, normal project. You are still creating a partnership, MOU, MOA, a lot of these normal legal practices. You should have those in places. This is the example just I told you. Yeah. So coming to the conclusions, I think it's a very vast topic which I tried to cover in 1 hour. I think within 1 hour. But one part of it, if you are practicing in this field, or if you are a founder in this ecosystem, or you are just interested, or you're just a trader in crypto, or maybe anything else, or you find just insightful this field is very much interesting because your each day will be asked with a tough question, which is might not still be, you can say, created or evaluated enough for your specific problems. So supposedly you need to know the regulations are very fast, very rapid in this ecosystem, because government, regulators, all are evolving with you. Nobody knows the perfect answer. So if you're founder, you should be flexible enough with your structure. If you're a lawyer, you should be also flexible with your understanding of the regulation of this victim. And if you're a law student, or if you're just interested, not a law student at all, you are just interested in this field, you should be also keeping abrupt of what's actually happening in this field from a legal and regulatory point of view. And you should not ever think of a way how to dodge the legal side of this thing, because today might be you get an easy way out, tomorrow you might not. And if you all play on a right side of the laws in this whole ecosystem, maybe government and regulators will find it much more easier to believe this ecosystem and these innovations is really helpful for the society. So, yep, that's all my presentation. I think it's a little bit haphazard, but I think it's going to help you a lot. Yeah, back to Saloni. Yeah,
Thank you so much, sir, for such an informative
thank you,
and
everyone.
insightful session. If anyone have any questions, ask them in the comment section. Sir will answer them.
Yeah, sure.
Sir, there is a comment section on your right side. You can see the
Mm,
questions there.
yeah. Mm. Can you just read for one question? I couldn't find it. If there is a question.
There is a first question. What should be the initial step for a
Oh, got
lawyer?
it. Hmm. Yeah. So, what should be the initial for a lawyer who wants to get in the Web3? The first initial stage, it should be your first should be stage should be you should be very much abrupt with that um, regulations of the comprehensive regulators, means the economy which has already been developed. So supposedly USA, India, UK, and some sort of an European unions, if their regulations you started to read it, maybe some regulation are not pro Web3, but they're anti Web3 maybe. But if you can get a picture of both sides, you get a better understanding of an overall manner. Then your best start is should be try to be very much active into knowing this ecosystem, because we are lawyers, not a technologist, right? But here law and technology works so much in parallel tune. You need to have some sort of understanding how actually this world of this Web3 actually rotates and operates. So then you will have a better easy way. You can find another question. Mm, can a
And
DAO proper? Yeah, yeah,
yes, sir.
yeah. Can a DAO own property in its name? Yeah, if the DAO is incorporated, then that incorporated DAO entity can obviously incorporate a property under its name. It's possible. Please make is India for an ICU? What is the how book or website for contractual agreements possible? Exactly, book for contracts in Web3. I to still couldn't find it, because obviously that's the thing. It is so much new and novice in this ecosystem. But website, I can say you exactly not the website name, but if you can reportedly search in a Google uh, best Web3 suited agreements or contractual process, uh, how to do it, and then you can like find those agreements. But there are few of the websites now I remember. Lex Notes is one of the websites. From there you can find just Web3 related documental resources. And I think, and also Lawsico has also few of their courses in there. They have a lot of these resources available for Web3 or fintech and crypto related agreements and documentations. And mostly if you just find that uh, if you also very much active on the Twitter, the crypto and Web3 economy is very much alive. Twitter and Discord, there will find a lot of different groups and legal channels where there people share those kind of documentations. How NFT are issued? Yeah, very good question. Yes, it's mostly like supposedly the if the NFT project is incorporated entity, they launch those NFTs through another entity. We call it like a most probably NFT issuing SPV, means special purpose vehicle just created for the NFT issuance purpose. They mostly incorporate those entity into some offshore jurisdiction or some other countries, and from there they do this disclosure and private and public placement that hey, we are launching this NFT. This is the initial cost, initial token listing, and all lots sort of this disclosure details, and they'll launch through that. So, and they will have to have a NFT policies, uh, normal terms and services for that specific NFTs. What you can do with that NFT, what you cannot, what rights you are getting it, what rights you are not getting. Exactly, all those disclosures are there. Lot of the different smart, maybe a little bit crooked NFT companies, what they do, they try not to give lot of rights to the issuer, the users or the investors. So try to, when you are buying any NFTs, if you do, or if you're going through any NFT profile, try to read their terms and conditions, try to look into their policies, what actually you're getting or actually you're not getting.
Sir, there is one more question. What
Hmm.
are the internship options available as a lawyer in the Web3 regulation related stuff?
So it's not an very easy to answer question because the thing is, in this ecosystem, the companies had a, because the thing is this field is so much new and unique in a sense, they want a specialized lawyer from the start. But I think you should not try to go for internships into this kind of Web3 companies directly. Your first bet should be conventional boutique law firms, or maybe if you are a have that much of track record and good CV or resume, go for a law firms who are specialized into this kind of field practice, because there will find a lot of different projects altogether. So supposedly today maybe you are doing NFTs in issuance, maybe tomorrow you are trying a legal structure, maybe tomorrow you are giving a taxation advice. So you have to find the special law firms. Maybe in India, there is like Ikigai, Nishid Desai Associates, Try Legal, and also which law? Indus Law. Those are the and Spice Route. Some sort of manners they do this kind of crypto and Web3 related legal advisory. There is a lot of different core niche boutique law firms who are in this field, but those are not Indians. In UAE, there's a Calm Legal Consultants. In USA, there's few. Then UK, there are few. So it's more about try to find the lawyers who are working in this field for over a time and working in the law firm or maybe in firms. They can give you some sort of the suggestion advice. As working as a legal counsel, most of the situation what I found, I also started my interning into those conventional tech law firms, and there I found few of the projects where I could look into, and gradually my experience grew. Yeah. So as a lawyer, DeFi work available. See, DeFi is a completely different. If you are meaning to say that DeFi is a decentralized finance, but I think you more want to work is like whole Web3 ecosystem based work. Yes, work are available because as there is a regulatory or legal challenges faced by these companies, and they need lawyers. So for an example, is it would be astonishing to listen to you guys also. that top Web3 companies' biggest expenditure on their balance sheet is on lawyers' fees, because that much of a demanded these professions for them, because they need a legal structure, they need a legal advice, and you don't have. So supposedly if you just google it around, or if you just find a normal lawyer, you might not be able to get the services. So they need a specialized field, and they want to ch- give the post people a premium for those kind of consultants. So a lot of works are available. Recently there was a news that Amitabh Bachchan sold NFT. Yeah, see what happened. Supposedly you, I don't know exactly your name, but your profile is that ABC something something something, right? So you have your own identity, your own proof, your own individuality, right? NFTs is also like that, non-fungible tokens. So it's a unique one NFT. There will be not a single copy of that exact NFTs in whole entire universe. So that will be unique. There can be a multiple of it, but it will be maybe NFT hash A0B1SSS something. So there will be unique, like how our fingerprints cannot be replicated. That's how the like exact fingerprint it cannot be also. But when these celebrities, not only Amitabh Bachchan, Sachin Tendulkar has done the same in Indian context. I think few other Indian rappers has done it, or maybe more other people. I don't not exactly recalling what these people do. They collaborate with an NFT issuing company or Web3 issuing company. They give the some of their personality rights to that company, and if you own that NFT, then you might be having some piece of their rights. Supposedly, if you own an Amitabh Bachchan issued NFT, you might then get an exclusive opportunity to work with Amitabh Bachchan, talk with Amitabh Bachchan, or something like that. So that is not a 7 crores. Maybe it's more about not his individual right, is maybe I'm not exactly recalling the incident of what exactly he sold that NFT for, but it can be any of his movie props, it can be his exclusive autograph, or supposedly you've seen a lot of time there are a lot of the celebrities do auction of their treasured things. Supposedly the sunglass which has been owned by Shah Rukh Khan in one of the film can be sold for 40, 50 lakhs, 1 crore. So those kind of exclusivity, they just attach the digital ownership rights of that with that, and people buy it. And so when they buy it, that NFT will be the equivalent of the price of that actual real world assets of that entity. So maybe Amitabh Bachchan has done something like that, and maybe that is exclusive enough. And this NFT world works very much on the hype basis. So that's sold for 7 crore. I think you can have your question there, answer there.
Yes, sir. I think that's it.
Okay. Thank you for
Thank,
everyone for listening. Yeah.
thank you so much, everyone, for joining in. And thank you so much, Sashwat, for such a wonderful session. And I hope every student learn a lot from this class.
I
Thank you
hope
so
so.
much.
Yeah. Thank you so much. Yeah. Bye.